Hello, my name is Lila Gridley, and today I will be discussing armed conflict and protection of the natural environment. Here is a brief presentation overview. I will begin with an introduction and introducing the idea of the natural environment before moving on to issues at hand. I will also discuss the IHL legal framework of treaty law and specific protections before moving on to the framework of customary law and general protections. I will also cover two case studies, the Vietnam War and the Gulf War, before concluding with possible solutions to better protect the natural environment through IHL. So to begin, throughout history, the environment has remained a mute victim of armed conflict. I thought this was a great quote to open my presentation to underscore the issue at hand. Armed conflict, both international and non-international, cause immense damage to the natural environment, impacting ecosystems and people worldwide. Whether the natural environment is being targeted directly or serving as collateral damage, the consequences now and throughout time are indisputable. Legal provisions in the realm of IHL, ranging from specific to general provisions, do exist. However, enforcement is often an issue. In IHL in general, international armed conflict is typically subject to more rules than non-international armed conflict. This is also the case regarding protection of the natural environment and is problematic considering how many conflicts today are internal. So, what is the natural environment? There is no universally agreed upon definition of natural environment in IHL. Additional Protocol 1 fails to define natural environment, and there are varying views on what this actually means. Today, I'll be drawing from the International Committee of the Red Cross, ICRC, Guidelines on the Protection of the Natural Environment in Armed Conflict, to introduce the understandings of what natural environment is in a few key ways. They define it partly as the natural world together with the system of inextricable interrelations between living organisms and their inanimate environment in the widest sense possible. They also note that natural environment relates to external conditions and influences which affect the life, development, and the survival of the civilian population and to living organisms. For the purpose of IHL, it is important to understand the natural environment and how it's interrelated in the widest sense possible. The issues at hand. Throughout time, our technology and warfare methodology has evolved. As a result, so has our ability to harm the environment. For example, nuclear weapons are able to harm the environment and people in a way that was previously not thought possible before the creation of this technology. Warfare leads to environmental degradation, which in turn affects livelihoods of those in conflict-affected regions and beyond. Just because one area may be targeted does not mean that the effects are contained in just that area. So how do we see this? There's loss of physical land from bombs, for example, in which homes and crops may be damaged or lost. The pollution of water, soil, air, etc. can negatively impact quality of life by depleting essential resources such as access and quality of these resources. Can also lead to disease and harm ecosystems. The use of herbicides and chemicals and also the consequences of radiation makes land uninhabitable for humans, nature, and wildlife. It also causes death and illness. There is treaty and customary law applicable for the protection of the natural environment. However, it is difficult to apply, especially for non-international armed conflict, which leads to a lack of relevant case law to draw from, as violations are rarely taken to court. This also leads to a lack of legal precedent to draw from. Beginning with the legal framework of treaty law and specific protections, I'd like to focus on Additional Protocol 1 to the 1949 Geneva Conventions. Article 35, paragraph 3 states, "It is prohibited to employ methods or means of warfare which are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment." Article 55, paragraph 1 reads, "Care shall be taken in warfare to protect the natural environment against widespread, long-term, and severe damage." I'd like to stop there because while both articles explicitly mention the natural environment, they have a triple cumulative requirement of damage, meaning any damage must be widespread, long-term, and severe. They do not individually define these three terms, making the threshold extremely hard to define. Article 55, paragraph 2 reads, "Attacks against the natural environment by way of reprisals are prohibited." This just essentially means if a state's environment is harmed as a result of armed conflict, they may not retaliate against who caused the harm and target their environment as a result. Now I would like to discuss the UN Convention on the Prohibition of Military or any other hostile use of environmental modification techniques, (ENMOD) from 1976. This convention as a whole prohibits the utilization of the environment as a weapon. Article 1 reads that each state party to this convention undertakes not to engage in military or any other hostile use of environmental modification techniques having widespread, long-lasting, or severe effects as the means of destruction, damage, or injury to another state party. This is a key difference from Articles 35 and 55 because it is not a triple cumulative, meaning the threshold is lower and in theory could be easier to define because you don't have to prove that all three are true at once. This convention largely served as a reaction to the use of large quantities of chemical defoliants that led to extensive human suffering by the USA during the Vietnam War, something I will discuss further later on. However, the use of this chemical defoliants led to death, cancer, other illnesses, mutations, and birth defects. Now for customary law and general protections, I will again be drawing from the ICRC Guidelines on the Protection of the Natural Environment from 2020. Rule 5, the principle of distinction between civilian objects and military objectives, reads that no part of the natural environment may be attacked unless it is a military objective. This has become an established norm of customary international law applicable to both international armed conflict and non-international armed conflict. I just listed below where the codification and applications apply. This could be considered a more ironclad protection of the natural environment because to identify part of the environment as a military objective, it must be extremely specific, like say a certain cave, for example. It also must meet the two requirements of any military objective, that it would have a clear military gain and that partial or total destruction shows clear military advantage. Rule 7 is proportionality in attack, which reads that launching an attack against a military objective, which may be expected to cause incidental damage to the natural environment, which would be excessive in relation to the concrete and direct military advantage anticipated, is prohibited. This also essentially means that the outcome must not outweigh the action being taken. The natural environment is considered civilian in character, so any part that is not a military objective must actively protected against both direct attacks and incidental damage. The incidental damage component is key because the environment often suffers as a consequence of other armed conflict and military objectives. The first case study, the Vietnam War, focusing on the years 1960s to 1970s. During this time, the United States used Agent Orange, a toxic herbicide that led to mass deforestation and chemical contamination and caused, as aforementioned earlier on, death, illness, birth defects, and so on. I wanted to include the statistic to exhibit the extent to which this chemical contamination reached. Approximately 70 million liters of herbicides were sprayed over the country's forests between 1962 and 1971, dousing 1.7 million hectares, often several times over. Over 1,239,000 people were directly contaminated. This goes to exhibit both the environmental and human impact of this contamination. This was extremely significant because these actions led to extreme concern from the international community, which ultimately led to the creation of ENMOD in 1976 and Articles 35 and 55 and AP1 in 1977. This is one of the most prominent examples of how armed conflict harms the natural environment in addition to the human population. Included this image to show that a way in which this herbicide was delivered was through the use of planes. Another statistic that 5 million acres of land, or 12% of South Vietnam, was sterilized, which is key when we talk about the agricultural consequences of armed conflict. The second case study, the Gulf War from 1990 to 1991. We saw by the retreating Iraqi army in Kuwait the intentional destruction of over 600 oil wells, which evidently led to extensive pollution and damage, an estimated $85 billion worth of damage. Applying the principle of proportionality, experts considered this disproportionate, meaning that it was excessive in relation to the direct military advantage gained. Therefore, many experts consider that these actions should be considered illegal. This is also key because it led to the questioning of the efficacy of NMOD and Articles 35 and 55 of AP1 because these were created before this happened. As a result, many believed there should have been a fifth Geneva Convention held. However, instead, the UN General Assembly met for debate in 1992 on the protection of the environment in times of armed conflict, which led to Resolution 4737, an example of soft law that encouraged UN member states to further comply with existing international law and incorporate protecting the natural environment into military manuals. Possible solutions to better protect the natural environment through IHL. One of the best ways to do this is to enhance and strengthen existing legal provisions. A good start would be to define natural environment explicitly in AP1 so everybody's on the same page. It would also be essential to define long-term, widespread, and severe damage in AP1 Articles 35 and 55 because they are currently not defined and their lack of definition actually makes it harder to determine when violations are made. Also, the triple cumulative threshold should be lowered from long-term widespread and severe to long-term widespread or severe. This, in conjunction with the clear definitions of the three, would make it a lot easier to establish when there are violations made and how to go about that. There should also be more anticipatory legal provisions with specificity instead of waiting until something happens that has to be addressed. For example, the actions of the United States during the Vietnam War led to the production of NMOD and Articles 35 and 55. However, following the Gulf War happened, and these were deemed not effective enough, which led to Resolution 3747. Instead of making all these provisions after the fact to hopefully prevent for the future, there should be more provisions ahead of time to hopefully prevent damage to the natural environment. Finally, it'd be extremely beneficial to actually address violation through legal channels. This would lead to relevant case law and a legal precedent that could help countries understand the importance of protecting the natural environment and the legal obligation they are held to. Listed here are my references in APA format. This concludes my presentation. Thank you for your time.